I'm going to talk about a concept in workers' comp, how Bureau of Workers' Comp, BWC, work injuries, etc. This concept called voluntary abandonment. So you might run into this if you've been injured. Uh, you know, it, this is kind of can determine whether you get compensation or not. So that it's kind of an important thing, um, and I'll briefly go over it. So if you voluntarily abandon the workplace, then that means you're leaving work not because of your injury or whatever. You're leaving work. You're actively choosing to leave work. You're doing something to leave work. You chose to do it. You've quit. You've resigned. There's other ways that you can voluntarily abandon the workplace. So if you voluntarily abandon the workplace, then you are not entitled to temporary total disability compensation. If you've involuntarily abandoned the workplace, you are entitled to temporary total compensation. Now, how does this work? How does this play out? One of the things, and I'm basically going to talk about one specific area of voluntary abandonment, and it's called workplace rule violations. And this kind of situation arises, a workplace rule violation arises in situations where you've had a work injury, you're going back to work on a on a restricted basis, uh, and and then you do something, you get fired. Um, so what is a workplace rule violation? So it's got to be a written workplace rule violation, and it came about in this case called Louisiana Pacific. But there's three parts to it. There's clearly defined prohibitive conduct. There's previously identified as a dischargeable offense, and the injured worker or employee rather knew or should have known about this written workplace rule violation. And a lot of times these written workplace or these written rules will be in employee handbooks. So if you're given at any time an employee handbook and you sign something, there might be a rule, you might not have read it, but you should know, if unless it's some bizarre obscure thing, then you knew or should have known. And I think one of the ways this plays about is, let's say you get injured and you go to the hospital and they give you this off work excuse letter or whatever, and so you're off work for whatever 3 days, and then you don't keep in contact with your work, you're not telling them what's going on, and so the fourth day, for whatever reason, you stay off work because you're still hurting. You don't call them, you don't let them know what's going on. The fifth day, you don't call them, you don't know what's going on. The sixth day, same thing, you don't call them, you don't know let them know what's going on, etc. And let's imagine in their employee handbook it says, if you're going to be off of work, you need to contact your manager and get an excuse to be off work. And each one of those violations, you get a point. And let's assume at this, again, just for the sake of argument, at this job, you can get a total of 3 points. If you get 3 points or more, then you're terminated. If that were to happen, and then what would the effect of that would be is you might have workers' comp claim, and you could still have your medical paid for, but that would consist of a workplace rule violation, because there was again, there's clearly defined conduct in the workbook. You got to let in this case, the example, you got to let your manager know that you're going to be off. It's previously been defined as a dischargeable offense. It says in here you get X number of points. If you get 3 or more points, you're fired. You knew or should have known. Again, unless it's some bizarre obscure thing, then you should have known that if you got X number or more points, you get fired. So in this case, if that came up, you're not entitled to compensation. You've voluntarily abandoned the workplace by violating this workplace rule violation. Another place that this plays out is, let's say you get injured and you're going back to work on work restrictions. and let's say you're getting working wage loss, which is a type of compensation which we could talk about at a later time. But let's say you're getting this compensation, and they do a drug test. So you've already gotten injured. You got your workers' comp claim. You're getting this working wage loss because you're not able to work as many hours as you had before, and you're not able to work because of your work injury. They do this drug test, and you test positive for marijuana. Well, again, in their manual, it says if you test positive for marijuana, then you are, you're going to be terminated. So in that case, again, it's a workplace rule violation. So, and that kind of, I'm going to segue into the timing of these workplace rule violations. But I guess the biggest thing you need to take away from this is that if you have a work injury and you're going back to work, you have restrictions, you have to understand at that point you're in a fishbowl. If you've ever heard the term fishbowl, you're in a fishbowl. You have a magnifying glass on you. You have a scarlet letter. You're being watched like a hawk. So your employer is gonna, and unfortunately this is the way it is because you're costing them money. But your employer is going to be looking for any reason to lessen their exposure, lessen the amount of money they're going to have to pay for your work injury. And an easy way for them to do that is to, find that you've violated a workplace rule violation. And then you might say, well, that's a retaliatory discharge. And that's where it gets hard to prove that. And if you have clearly violated a workplace rule violation, it's going to be hard to, and they have a document and they have you dead to rights. I mean, you're kind of SOL at that point. Now we'll go to a hearing, we'll go to a hearing for you, but sometimes you can prevail, sometimes you can't, depending on what you did. So I'm going to segue into the timing issue of these workplace rule violations and how this has kind of been defined. So, and then I'm going to go an example of a kind of an interesting situation that I've ran into in a case or a hearing issue that I had at one point. So they have these, so it's got to be, it can't be, the workplace rule violation can't have happened. They can't use a workplace rule violation that happened before or at the same time as the work injury. So it has to be a workplace rule violation after the injury in order to be a workplace rule violation, or in order to be involuntary, or rather voluntary abandonment. And this is kind of encapsulated in this case called, it's named the French fry case, and or the fry case. It's called Gross 1 and 2. And essentially this kid worked, I think he was a teenager, possibly a teenager or a young adult rather, and he worked at a fast food joint. And he was, I think he was cleaning out the fryer. And if you've ever had to clean out fryer, those things are frightening. I had to do that in college. It was always scared me when I worked on the fryer. One, you smell like the fryer, and two, there was always this scared the heck out of me that I was going to, maim myself, burn myself in the crazy fry grease. But basically what happened is he somehow burned himself very badly. I don't know if he stepped in it or he spilled it on him. The point is he's cleaning out this thing and he gets burnt by this fry grease. So the employer tried to say that was a workplace rule violation. How? Because there was a workplace rule that said you had to clean the fryer in a specific way in order, because otherwise you can get in a situation like this guy and get burnt. So he didn't follow that rule, and because of that, he burned himself. In that case, the court found that, again, pre or contemporaneous contact cannot be construed as a workplace rule violation. And so in this case, he violated the workplace rule at the same time he was injured. So, and therefore, no workplace rule violation. How can this also play out in interesting ways? Okay, so I had a situation where we had a injured worker. I think he was working in a factory or something, and I don't, not to get into specific details, but he ended up hurting himself. And most jobs I've encountered is they like to do these post-accident drug screens. So you get injured, you go to the hospital ER, they're going to say, was this a work injury? And you say yes, and they're going to do a post-accident drug screen. And your employer is usually going to require that you do them within, X amount of time, 12, 24 hours after the injury, if not sooner. So in this case, the individual, the usual course of things is, let's say you smoke marijuana, and marijuana, the metabolites stay within your system. If you smoke, let's say over the weekend, and you go to work, on Monday or Tuesday or whatever, you're still, if you get drug tested, you're going to test positive for marijuana. Doesn't mean that you're smoking marijuana job, but that's the way it works. So the way this plays out in the workers' comp world is, if you test positive for marijuana, in terms of your job, that's sufficient to fire you. So your employer is allowed to fire you. They could fire you. But in terms of workers' comp, so then the issue is, well, if they fire you and you have an injury and either you have restrictions, they can't give you restrictions when you don't have a job anymore. So you either have restrictions or you're completely taken off. As long as you're medically qualified to be entitled to TT, you should get TT. So in this case, it's sufficient, but the point is, it's sufficient to fire you, but it is not a workplace rule violation. It is not an involuntary abandonment of the workplace. It was pre-injury conduct. You can't use pre-injury conduct to exclude somebody from getting TT. And the reason why, it's kind of a policy thing. It kind of makes sense when you think about it, because otherwise, employers, what they would do is, for every employee, they'd have a dossier of bad things that the employee's done in the past that would be sufficient to fire them. And then what they would do is they would, you get injured and they'd say, oh, we'll see at your dossier. Okay, yeah, you did this, workplace rule violation. You voluntarily abandoned the workplace. No, you don't get any comp. So the state of Ohio, or the Supreme Court, has defined that for policy reasons, it's not a good policy to have. It's not. It's just shady. So, but how? Again, ran into an interesting situation. So this guy gets injured in the factory. He goes to get the post-accident drug screen, and he's filling the bottle, and the nurses or whatever, and basically they're saying, hey dude, you didn't fill in this, it's not filled sufficiently. He, for whatever reason, he couldn't stay there to drink more water and pee more to fill it. And I wasn't there, but point is, at the hearing, the issue was, it was kind of an interesting discussion where this is a post-accident drug screen. So you would be testing, if you got injured if you got a post-accident drug screen, you'd be testing for drugs that you had taken, prior to the injury. But in this case, it wouldn't necessarily be the fact that he, let's say he violated, and this wasn't the case in this situation, but the situation, it wasn't that he had, possibly smoking weed or was drunk or whatever. It was the argument was that he violated, after the injury, a workplace rule violation, because he, refused to completely fill in this cup in order to do this drug test. So it's interesting. The employer didn't prevail. He ended up, getting the claim allowed and getting TT and all these things. But I guess the takeaway from that is, when you go to get these post-accident drug screens, just go ahead and do them. If you're afraid you're gonna get fired or something, just, that's a choice you make. Just don't smoke weed or drink or whatever. I guess, and I know a lot of people smoke weed or marijuana, and they argue, it doesn't affect me. I honestly don't care either way. I could care less from my own personal standpoint. I don't care if you smoke weed. That's your own decision. Just realize there's repercussions doing so. even with this medical marijuana, it's going to define. You're still really probably not going to be allowed to smoke weed. I don't think employers are going to give. They're still going to use that as a way to fire you. So those are the breaks. I don't know. Get a white collar job where there's no drug tests, which is weird. But so that's basically the way it works. And I think the biggest takeaway from this is if you get injured, you're going to be in a fishbowl. You have the magnifying glass. They're going to be watching you like a hawk. You got to follow the rules. Even more so, let's say you got away with stuff in the past, and let's say your coworkers get away with stuff. I don't care. You're injured now. You're in almost like a special category of surveillance. So you follow the rules, and you won't have a problem. Don't follow the rules, and you might find yourself in a bind. So again, hopefully I've helped explain something, or I've illuminated an area that you didn't quite understand. If not, and you're one of our clients, as always, call, email, talk to us. We'll explain it in detail. And if you're not represented, again, as always, I highly recommend you find an attorney, whether it's our law firm or another law firm. There's a lot of law firms in Columbus do workers' comp. If your injury is anything that's going to keep you out of work for more than a few days, it's just worth it. This whole system's so unnecessarily complicated that it's worth getting an attorney. It's going to pay dividends, and I recommend it. Again, whether you go with us or some other attorney, get an attorney. I think it's a good idea. Otherwise, have a nice day. Bye. 99% of people do not want to get injured, but it's not like a benefit. It's to be on workers' comp. It actually, all things being equal, you would much rather be working. So, that's why you want to get the treatment you can, and then go back to work if you can. If you can't go back to work, you can't go back to work. But that's kind of basically the way it works. So that's your AWW, your wage rate, how you set your wage rate, how you could get your wage rate increased, and then also the FWW and AWW and how those are paid out. And hopefully this put a little bit of explain it a little bit as possible. I've made it as clear as mud. So if that's the case, as always, if we represent you, call anytime, email anytime. We'll explain this in excruciating detail, go over this whole thing over and over until you understand it. If you're not one of our clients, watch this video. Hopefully you understand it. Hopefully it gives a little bit of an explanation of it. Alternatively, just call your attorney. And if you don't have an attorney, if you have a serious enough injury, I'd recommend getting an attorney. I'd always recommend with this BWC stuff. So if not us, Malek and Malek, there's a lot of good BWC attorneys in Columbus. Get an attorney. It's gonna pay dividends. All right. Thanks for being patient and watching this video. Hopefully it's helped you.